Welcome back to Google class. This is also a previous video class continuous because due to technical problem suddenly switched off. So I'm continuing that portion, flight versus booth case law. Okay. Here the Chief Justice Tyndall observed that it must be of such a nature that it might be reasonably supposed that if the buyer had been aware of it, might not have been entered into the contract at all, for he would be getting something different from what he contracted to buy. Okay, this is what's explained the above identical example also regarding latent defects in property. Okay, we discussed earlier video. Now let's start same TP Act, Transfer of Property Act, the definition of defects in title. Okay, what is the meaning of defects in title? The rule of caveat emptor does not apply to defects in title. Okay, the seller has to disclose all defects of title pertaining to the land. However, the defects known to buyer need not be disclosed. Examples of defects in title means: number one, an encumbrance. That means is any disputed land or disputed property. Okay, must identify, and we don't know transparently, we don't know visibly. And then a notification of intended acquisition under the Land Acquisition Act. Okay, nobody land acquisition in transparently, invisibly. Okay, and these are all defects in title. A third point, notification of intended acquisition under Urban Land and Sealing Act or under Agricultural Land Sealing Act. Okay, these are all acquisition from the government. And then a restrictive covenant, then easement. Sometimes easement area also very defective, and a neighbor and this owner of the persons also already disputed, the passage also not properly assigned in this particular area. So the easement problem also arose that particular property. So these are all defects in title. So this titles must inform to the buyer. Okay, this liability is from the seller side. Okay, it is the duty of the vendor to disclose such defects to the buyer. If the vendor does not disclose and the buyer discovers a material defect in title, he can claim damages also or rescind the contract for misrepresentation. Okay, and burden of proof. Here the burden of proof showing a failure to disclose a defect in title, the latent defect is on the buyer. And another part, duty of the buyer. Duty of the buyer. It is the duty of the buyer to inquire into the title of the property. He has to inquire into the latent defects, particularly regarding the defects in title. He has to go to the register office and inquiry and apply encumbrance at EC certificate also, and get the encumbrance certificate, and shall have to inquire with the neighbors with the reasonable sources. Okay, that's all your students. This caveat emptor is over. We'll discuss the same subject next video class. Okay, and another section, I think so, not I think so, another section 55 subclause, only 55, that is 55 subclause 4, unpaid vendor's land. Okay, we'll discuss in next class. We'll meet you again, students. Take care, all the best, bye.